And we want to bring in Kaysia Earley, a defense attorney and former prosecutor. Thank you so much for your time.
Thank you very much.
Now, we know
Thanks for having me.
this is a rancher who has people coming and going on his property. Is self-defense an option here?
Self-defense is definitely an option, but the defense is going to have to put forth the defense as what was reasonable. That's the standard in Arizona law. So we know that the alleged victim in this case was found unarmed, but we also know that he was approximately 150 to 200 yards away. And there were clearly no trespassing signs. There's clearly gates and barbed wire. So did he go beyond the gates, beyond the barbed wire? And of course, you have to go into the defendant's state of mind. He is 78 years old, elderly, along with his elderly wife. So was he in fear of this trespasser to the point where it was reasonable enough for him to justify in using deadly force? So as the evidence unfolds, I'm pretty sure that we will have those answers.
And let's talk about this $1 million bond. Does that actual amount surprise you? In this case of a man in his 70s who takes care of his wife, he seems to have no prior record.
Not at all. Typically with cases, especially with murder, you're going to see a high bond, especially in the early magistrate phase and arraignment. It is, of course, the defense attorney's job to go ahead and file a motion to reduce bond. And with this motion, the defense attorney can detail Mr. Kelly's ties to the community, of course, his age, possible any health concerns that he may have, to show the court that he's not a flight risk and that he lacks the financial capacity to post a bond, because, of course, that would be cruel and unusual punishment just to have him sitting in jail when he cannot post that particular bond. So there's other forms of pretrial release.
And as you mentioned, still much more to learn about motive or what exactly led up to the shooting. Is there anything that could emerge that could meaningfully change things in this case?
Of course, but in a case of self-defense, typically the defendant would have to testify to show his state of mind, to testify that he was under great fear, that he had to utilize and was justified in utilizing deadly force, either to protect himself or, in this instance, to protect his elderly wife. Typically, when there are illegal or undocumented immigrants, you don't know their state of mind. They're in a state of desperation. So perhaps he believed that this particular illegal immigrant was in a state of desperation and he feared for his safety, which resulted in him utilizing deadly force.
So it would not be enough to say he was simply trespassing on my property and I have no trespassing signs and he shouldn't have been there?
Not at all. That would be a defensive property, would not justify utilizing deadly force. It has to be a reasonable standard.
Okay. Kaysia Earley, appreciate your time. Thank you so much for being here.
Thank you for having me.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your television provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.